What's up, peeps? Welcome back to the Range Minded Podcast. I'm your host, Steve Zimmerman, and I'm excited to have you here. By the way, if you haven't heard, the podcast was nominated for a Gundy. That's right, Podcast of the Year, which I'm extremely honored and grateful for, just to have the opportunity. By the way, voting ends on December 15th, so you still got a few days. Jump on there, take care of that. You can vote at least once a day. Go to thegundys.com. Go through your votes of your favorite 2A creators. If you just want to vote for the podcast, it's down towards the end of each tier of the Gundys there. But Podcast of the Year, vote for the Range Minded Podcast. That would be awesome. Now that we got that out of the way, let's get to the meat of the show. So believe it or not, I actually recorded a show last night. So this is December 8th when I'm recording the show. I recorded a show last night. I hated it and I deleted it because it absolutely sucked. So you're getting a much better deal for your dollar now. So yeah, I guess we'll just leave that in there. I don't even know where I was going with that. But in this episode, I wanted to talk about something different than I talked about last night. I think that's why I was going there. And I'm not even going to tell you what last night's show was about. Tonight's show, I wanted to talk about what is our future state of the Second Amendment, meaning in at least the perspective of the Supreme Court. Now, this term or this session of the Supreme Court has a lot of potential for the Second Amendment, whether it be good or bad. And I think we need to look at it. As an informed gun owner, I think it's important for you to see what is coming down the pipeline. And I found it kind of interesting, some of the stuff that this session of the Supreme Court is looking at. Just by way of understanding, the Supreme Court term or session, whatever you want to call it, goes from the first Monday of October into the end of June. Sometimes it rolls into early July, but usually they try to finish up at the end of June. So that gives you a few months, or at least gives them a few months to hear a lot of cases. They hear a ton of stuff during that session of the Supreme Court. So to get some real big, high-profile cases that take a lot of time are important. I mean, it takes up a ton of their time. So they're gonna take the time that they need to really think and contemplate what they're hearing. And there's two 2A cases that are slated to be heard in this session of the Supreme Court. And I think we need to talk about those, but there's also a bunch of other ones that have been submitted but haven't quite made it to the desk of the Supreme Court justices. So I'm going to reference my show notes quite a bit because I want to make sure I don't miss out anything of what we're talking about here. So the first one that is actually slated to be heard is Wilford v. Lopez. Now, you've probably heard about this court case already. This is involving Hawaii's concealed carry ban on private property, unless the private property owner openly and explicitly expresses that the concealed carry holder can carry on their property. Now, in free states, usually concealed means concealed. The property owner, they can put up a sign that says no weapons allowed. Otherwise, the concealed carry holder can take their firearm in. And honestly, concealed is concealed unless they know they're not going to do anything, and at worst, you're going to get slapped with a trespass, and that's it, at the worst. But Hawaii, which has not been traditionally pro 2A, decided that they're going to take the sensitive area to the extreme. And they're going to say, unless any private property owner explicitly gives consent for the Second Amendment or for concealed carry, then it is absolutely prohibited. Now think about the issue here. How much private property is there in the state that you live in or in the city that you live in? Quite a bit. that means that the concealed carry license holder, the CCW holder, is limited to sidewalks, unless there's some kind of county ordinance or city ordinance or whatever that prohibits firearms in specific areas like courtrooms, hospitals, that kind of stuff. We already know that exists. But that really neuters the opportunity for concealed carry completely. When a state encourages private businesses to explicitly express that someone can carry instead of the opposite, then it's basically a ban. It's a blanket ban for the CCW holder. And Hawaii, the leftists understand this, just like New York and other states. They understand that, and that's why they're doing this. And that's why this has gone to the Supreme Court. Okay? So the Ninth Circuit upheld this thing, right? Upheld this ban, which is ridiculous. Some other circuit courts have been kind of split on this, and that's what's caused the confusion. And that's why it was petitioned to the Supreme Court. Now, the petitioners, who are the people saying, hey, this is BS, are saying there's no historical tradition to this. Now, the Supreme Courts and, honestly, district circuit courts, they're all supposed to look at the Second Amendment under the Bruin test, right? That the text, history, and tradition. So the petitioners are saying there is no historical analog to this ban for private property. Nothing. So what the states that are doing this, specifically Hawaii, obviously in this case, is they're violating the Bruin test. There's no analog in history that exists for this. And the NRA and Gun Owners of America, they've also got involved in this case because this is a big deal. This is a big deal. Now, this doesn't just change Hawaii. You got to understand, if the Supreme Court rules on this sensitive areas place or the private property case in this specific version, sorry, I'm a little tired and slurry here. It doesn't just affect Hawaii or the residents of Hawaii. This could have implications nationally, and it's important to understand that. Okay. But Hawaii, Lopez, their AG there, she says that private property rights trump the Second Amendment, and private property owners have complete authority to deny Second Amendment rights. So this gets kind of confusing. This gets kind of messy. Again, the anti-gun crowd knows exactly what they're doing when it comes to this. There's no whoopsies, I didn't understand the law. No, they're doing this on purpose. Now, they're citing that there are some historical analogs for innkeeper's discretion on not allowing arms on their property. So we're going to see how this goes. It should be pretty interesting. It'll probably be mostly boring. Hopefully when they do hear this case, I'll have some time to listen to some of the oral arguments so you don't have to. I do kind of enjoy listening to some of the spoutings of the justices and their questioning. You get to hear who grandstands and uses it as a political microphone and who actually digs into the text, history, and tradition. It's good. Honestly, I don't mind having justices that see things from different perspectives because I think it's important that we really analyze some of these decisions before they become law. So we'll see. It was originally filed to be heard in November. So we'll see what happens. This really could impact many, many states, and it impacts property owner rights and impacts CCW coverage. So this should be interesting. We'll see where this goes. Now, if the Supreme Court sides with Williford, in this case, the Pro 2A side, it expands concealed carry rights nationwide, right? Many states are going to be affected. That means the no gun signs will need to come down, which, again, this kind of trifles on private property ownership. So there's going to be lots of confusion when this happens, if it happens. Spaces that are commonly open to the public, they're probably not going to be able to restrict your protected rights, which would be interesting because this might fall into, if you've watched like the First Amendment auditor people, which I do kind of fall into that trap once in a while. If the Second Amendment case gets changed, that could change how First Amendment laws could be effective as well, as far as filming in public. This has bigger implications than just Second Amendment stuff, and I don't think anybody else has even talked about that side before. But it really could change how recording in public and private spaces are done too. Maybe down the way a little bit, but it could be something that could be used to argue the First Amendment stuff, the First Amendment auditor stuff down the way, which I think could be really interesting to understand. Now, if they side with Lopez and the private property ban stuff, it's going to create gun-free zones all over the place. And it's going to be a nightmare. And it's going to be very, very difficult for law-abiding gun owners to defend themselves, throughout places in the United States. So there are big implications here, and we need to really be paying attention to it. I think we're going to see Justice Thomas and Justice Alito really lean on the historical side. But when it gets to Kavanaugh and what's-her-face, I mean, who knows? It's a wild card. I'm going to talk about some of this stuff a little bit later. I've got kind of a little bonus part of this video, this podcast later on at the end, that I typed in. We'll get to that point. I'm just going to tease it that far. Stay tuned to the end, because there's some interesting stuff that I did on all these cases at the end of the show. So the next one that's slated to be heard by the Supreme Court, and I don't know when for sure, is the Hamani case. Now, there's a lot of YouTubers talking about the Hamani case right now, because this really is an important case as well. Yes, the Hawaii case is a big deal because it could create gun-free zones across the United States if they don't side with the 2A. But this case is important too because it deals with marijuana and states' rights versus federal laws, and how gun owners that may be using medicinal marijuana are being forced into this really uncomfortable and possibly lose their rights for using something that's legal in their state. So Zan Hamani is a Texas resident who was arrested and under the influence of marijuana and also having firearms. Now, federally, marijuana is still a scheduled drug. That's why when you fill out your 4473, it's going to ask you about, do you use an illegal substance? And marijuana, since it's scheduled, is going to fall under that question. So you fail a background check if you say, yeah, I use drugs. But states' rights say, yeah, this drug is legal in our state. So it creates this dichotomy, right? So what does this mean? Now, a lot of dudes are saying that Hamani, as an individual, and I guess as this case, all in one, is a bad idea. Like he's a bad example of this particular problem, and it's not going to end well when SCOTUS hears this case. Now we got to look back. Like, the reason why this case came up is, again, we have to look at the Bruin test as an analogy of what the future holds. So Hamani says, hey, there is no historical example of somebody under the influence of marijuana that's been prohibited of their rights. Yet the DOJ says it's a controlled substance, you're under the influence, and there are many examples historically where people under the influence have their Second Amendment removed. That this is a big decision for the Supreme Court, and it is something that we as gun owners should be really involved in and interested in, because let's just say the Supreme Court says, okay, there's any kind of marijuana use is done deal. Like, you can't use marijuana and have your Second Amendment rights. Well, that jeopardizes millions of Americans who legally use within their state, maybe for pain or depression or cancer. There's a lot of uses for marijuana that are on the legal side, prescribed side. Yeah, I also understand there's a lot of illegal use. I totally get that too. But those that are prescribed and are legally using the substance, they're going to lose their Second Amendment rights. Is that fair that there's a disparity in laws that will take away these individuals' rights who are not using it maliciously? I don't know. That's something for the Supreme Court to decide. Do I think there's a medicinal use for marijuana? Yeah, absolutely. I don't like the idea of using any kind of drug that impairs your judgment or your ability to think freely. I think that's a mistake. Do you have the right to do it? I guess in your own home, maybe. I don't know. I might be a little bit more libertarian when it comes to that. I don't like substance abuse, but maybe if it's something that you do in your own home and you're not harming anybody but yourself, maybe it's okay. I don't know. But that's not what this is about. Again, Hamani wants the Bruin test to be used here. As far as I understand, I don't know of any use of cannabis or marijuana during the founders' time. There might be. I don't know. I didn't look into that point. But it's a non-violent habit, right? If you're well, I don't know. That could be argued too in some other ways. But that's at least Hamani's example. Like, there is no example of marijuana use and violent cases happening from the founders' era. If Hamani wins, okay, this will force state law and federal law to align. So I guess marijuana will have to be taken off as a scheduled substance. Maybe some people rejoice in it, some people don't. I personally don't like it. If Hamani loses, then it's causing some folks to think, okay, well, what about individuals that are addicted to alcohol? Addicted to alcohol or legally use alcohol, right? Even though alcohol is not a controlled substance, does it open the door for confiscation of individuals that are impaired by things that are not illegal at this point? Could be. That's one thing we need to understand is all of these decisions that happen at the Supreme Court level reconfigure on how the anti-gunners attack things, and they're going to just find another avenue to attack law-abiding gun owners. So it could be interesting. It could be interesting. I don't know exactly what to think of this one yet. I'm not sure when the Hamani case is going to be listened to. It was granted cert in October, so we'll see. It's got to be, some people are saying it's going to happen before, or at least right at the beginning of the year. I don't know. I guess we'll see. It could be interesting. So those are the two cases that for sure are slated to be heard. But now let's go through some of the ones that are kind of waiting in the wings. There's quite a few. There's a few that could have implications. Gosh, I cannot talk right now. Let's see. So let's jump to these ones first. First are some that involve 18 to 20-year-olds. These have been submitted to the court, but they just haven't. The court hasn't decided to say when they're going to hear these. So let's see. The first one would be the NRA versus Glass. This is the NRA sued Parkland. Oh, this is post Parkland shooting in Florida. So Florida set up this ban for 18 to 20-year-olds to purchase or to have transferred to them firearms. The 11th Circuit Court back in the day upheld this ruling, but the 5th and 8th Circuit said, whoa, you can't do this. So it created a split, which then obviously allows the Supreme Court to jump in there. The NRA, they filed this petition in the summertime of this year sometime. And they're saying that 18 to 20-year-olds, that age group, 18-year-olds were allowed to be in the militia, and there's history of that happening, during colonial times, during the founders era. 18 to 20-year-olds were involved in militia. They were given arms. They were expected to have arms, and they acted prudiciously under those sanctions. And if you use the Bruin test, it will completely uphold that 18-year-olds and up can carry and purchase and possess arms. There is no ban according to age back in the day. Now, okay, hold on. Okay. Also, some of these younger shooters that want to be law-abiding, obviously this infringes on their rights. And there's other states that have these restrictions as well, and we're going to talk about those in a second. But the young shooters are saying, hey, as an 18 or a 20-year-old, I'm going to war. I'm allowed to vote. I'm technically an adult. Why am I being denied my Second Amendment rights? And rightly so. I agree with them. They're also being denied their ability for self-defense, at least limited on what they can use, what tools they can use for self-defense, which I think is obviously a violation of their civil rights. But Florida doesn't really see it that way. We also got to remember Pam Bondi was involved in Florida law, so I mean that is what it is. But you have DeSantis as the governor there. It's very confusing. It's very confusing what's going on in what's supposed to be a free state with what's supposed to be a good governor. But we'll see. Now, if the Supreme Court sides with the Second Amendment on this, obviously we're going to see 18-year-olds and 18 to 20-year-olds, I should say, they're going to be allowed to purchase and possess firearms, which they absolutely should be. Again, they're voting, they're going to war, the government gives them weapons of war. Why are they not allowed to have something that's inferior for their self-defense purposes as civilians? It's really ridiculous. I don't understand. Another one that's very similar to that is Paris v. Lara. This is in Pennsylvania. Kind of the same thing. Again, it's a ban from 18 to 20-year-olds. Third Circuit was kind of split on it. The goal is obviously to get that completely reversed and allow 18-year-olds to 20-year-olds to carry and possess. Because, again, there's no historical and analogous or historical example of it in the Founders' era. So, again, if the Supreme Court sides with the two-way on this, it allows young adults to possess and carry for self-defense. The Lara case also has to do with concealed carry, so it'll also allow these younger folks to conceal carry for self-defense as well. Obviously, if the Supreme Court fails to side with the Second Amendment, then I guess these young adults have to wait till they're 21. Now, some people say it doesn't matter, age shouldn't be a thing. Yes and no. Let me put it this way. I have seen very responsible 16-year-olds that understand and practice real gun safety. They understand the rules, and they're very good at what they do when it comes to that. And I've seen adults that are complete morons and are incredibly unsafe. So maturity is more than an age, but we shouldn't be denying somebody the right because of an age. And I think 18 to 20, they should be allowed to purchase and carry. It's ridiculous to deny those rights. If we lose, I guess they'll just have to wait till they're 21. All right. Another couple that are slated to be heard, but we just don't know when, and some of these names are going to sound very familiar to you, is Duncan v. Bonta and Gators Custom v. Washington State. So obviously the Duncan v. Bonta, that is the California more than 10 round magazine ban, which is really attacking standard capacity magazines, which is absolutely asinine. California's argument is that it deters mass shooting. It's going to stop mass shootings because they'll only have 10 rounds to use. I guess they don't understand how switching a magazine works. Of course, their ARs have stupid ways to change magazines out. But if you look at handguns, modern handguns, a lot of them have more than 10 rounds in them. So I guess they just assume that any kind of would-be attacker is only going to have one magazine, or it takes them 30 minutes to change a magazine out. It's completely unconstitutional. Many courts have said that, hey, magazines are necessary arms. There's hundreds of millions, if not billions, of standard capacity magazines in use in the United States today that are examples of the common use, which we know is also one of the criterias for the Bruin test. Well, I guess it would be Heller common use. So that's at least that's Bonta's side, right? Or Duncan's side, excuse me, saying, hey, we should be able to have these magazines. There's no reason to not have a standard capacity magazine. And the Gator case is pretty much the same thing. It's just has to do with Washington State's magazine ban, again, which is a 10-round magazine ban, or anything greater than 10 rounds. There's no history of an ammunition a capacity limit. There's no tradition of it. Now you're going to say, Steve, that's because they used flintlocks and they didn't have, well, guess what? They did have arms back in the day that had more than one patch and one ball. Look at the puckle gun. Look at the duck foot. Like, there's many examples of firearms that fired multiple rounds or had the capacity of firing multiple rounds, not just at the same time, but in succession, one after another. So that's a dead argument. That doesn't exist. There's no historical resemblance of any kind of capacity ban for ammunition. So we'll see if the Supreme Court sides with the Second Amendment on this one. That means at least 13 states are going to have issues with their capacity bans, which is great because standard capacity is standard capacity. It has nothing to do with how to reduce casualty in a mass casualty event. A murderer is going to murder no matter what. He's going to find any means necessary. So why limit somebody's defense if they can only have one or two magazines, while the bad guys aren't going to follow the laws anyways? They're going to have, 30, 40 round mags, 60 round mags. They're going to do what they want. So why hurt the law abiding? It's just ridiculous. And I know many of you guys feel the same way. We'll see. We'll see how this goes. This could be interesting. All right, the next one being, well, the next couple that we're waiting to hear is it has to do with felons, nonviolent felons. So you've probably already heard of Range v. United States. Now, Mr. Range, if you haven't heard about this case, which it's been around quite a bit, a lot of people are talking about this. Mr. Range was convicted of misusing food stamps. I don't know all the parameters exactly. I don't remember exactly what he did, but apparently he violated the use of food stamps. Maybe he had the money, but he was still collecting and using food stamps. Nonetheless, he became a felon because of it. Now, victimless crime. Nobody was ever hurt, injured, or killed. But the states decided to say, hey, he's now a felon because he misused federal funds. And so his deal is, hey, it's a nonviolent action. I'm the only victim in this crime. I should be allowed my Second Amendment rights because there was nothing violent about this crime. Some of the circuit courts don't like the way that sounds. They just look at you, hey, as a felon. They know that under ATF guidelines, under DOJ guidelines, if you're felon, you don't get your Second Amendment rights. Doesn't matter what the cause of that felony was, you're a felon, which is ridiculous, right? I think if you've served your time, if you've paid your debt to society, you should have your rights restored. if you go back to any kind of violent act, of course, violent felons, why are they walking the streets? They should still be incarcerated. But if you've paid your debt to society, or if you're a non-felon, or non-violent felon, man, I cannot talk. Woo. You shouldn't have your Second Amendment stripped from you. Another one, by the way, there is no history of disarming nonviolent felons. At least that's the argument anyways. There is no history. We'll see. Maybe they'll find some analogies of that back in the day. But we'll see. The Daniels case is going to be, it's waiting for what happens with the Hamani case, which we talked about earlier with marijuana. We'll see what happens. It may never see the eyes of the Supreme Court. We'll see. They're waiting on what happens to see with Hamani. Vincent v. Bondi has to do with felons, nonviolent felons. We'll see where that goes. It may not ever see the court as well. I don't know. I again, in my opinion, and I don't know if the Supreme Court sees it this way, if an individual that made some really dumb decisions, bad decisions, 20 years ago, have done their time, and the state sees fit that they're able to walk free out of any kind of facility, their debt is paid to society. They should have their rights restored. If they're violent, if they've committed some kind of violent act, they should not be out on the public streets, and they should remain incarcerated and thus not have their Second Amendment rights. Call me old-fashioned. The next one in this felon thing is, well, it's not really a felon, but it's Duarte. The Duarte case has to do with undocumented. This is kind of a hot take for some of you guys, and it's caused a lot of conversations online. The Duarte case has to do with undocumented or non-residents within the United States. Does the Second Amendment apply to them? Now, I can see both sides of this argument. The Constitution says we the people, meaning the citizens of the United States, but they're also not granted by the government. The Second Amendment is a restriction on what the government can do to your rights. It is not granting citizens of this country for anything. It is a restriction against government. So does that mean the right of the people to keep and bear arms, does that right go across to folks visiting the country or illegal immigrants? Now, you can say that, illegals are breaking the law, therefore the Second Amendment can't apply to those people, which there's a very good argument for that, and I don't necessarily disagree with that. But I also agree that the right for self-defense is a natural right provided by the maker and not by the government. So it's kind of an interesting debate. Again, this has caused a lot of discussions online. We'll see where that one goes. I'm curious to see if that even makes it to the Supreme Court. It might be interesting to see what the justices have to say about that, because it really causes an interesting dynamic when you have non-citizens within the bounds of the United States collecting welfare and other assistance. Does that mean they can get the Second Amendment right established to them, especially now they're getting driver's license, in some cases voting in some states? Then why are they not allowed to have a Second Amendment right? Or in turn, they're here legally, they don't deserve anything. So it'll be interesting to see how the Supreme Court handles that one. Far and wide on these few cases right here, these three cases here, when it comes again to nonviolent felons, I think if they've paid their debt, they should get their rights back. We'll see how that goes. It could be if they vote or they side with the Second Amendment, that means a lot of individuals will have their rights restored. If they do not see it on the pro 2A side, I guess it'll be just business as usual like we're seeing now. So it should be interesting. I want to know what you guys think about these cases, right? The two that they're going to hear, whether it be the Hamani case or what was the other one? Yeah, Hamani and what was the other one? I gotta scroll up here. Oh, the Lopez, the Hawaii case. Yeah, that's right. I'm interested to see what you guys have to say about these two cases that are slated to be heard, and what you guys think about the other ones that have the potential to be heard. There are some that you think are more important than others. I really want to know what you guys have to say. So don't be scared to throw those down in the comments. I read the comments. I reply to comments. I want to be involved with my viewers, not sexually. So don't be gross. But I want to know what you guys have to say. Like I say, I reply to the comments, so it's pretty interesting. So I asked you, or I didn't ask you. I said stay tuned because with some of these cases, I have something that I thought was rather interesting that I asked Grok about. I asked him. Here's the question I asked. I'm assuming Grok's a him. What are the odds of each justice voting pro 2A on the following cases, or on the cases that we just talked about? And I found this interesting. Now, Grok is Grok. Obviously, it's an algorithm, and whatever is input, it analyzes and regurgitates what it whatever, for whatever it is. Okay. So here's the odds, starting with the Lopez case. So the Wilfred Lopez case, which is the Hawaii case, excuse me. The odds of these justices voting pro 2A. So first off, it told me the historical pro 2A percentage. So Thomas has been 100% pro 2A, Alito at 95, Gorsuch at 90, Barrett, which is whatever you want to take her as, 80%, Kavanaugh 60, Roberts 50%, Kagan 10%, which doesn't surprise it's that high, Sotomayor and Jackson both at 5%. But here's the odds that they're going to vote pro 2A on the Hawaii case. Thomas 100%, and Grok seems to think he's going to rely heavily on originalist content, right? Like he's going to dig into the historical analogies. Alito, 95% chance of him voting pro 2A, leaning on his stance on the Bruin case. Gorsuch is going to be a 90%. Again, pretty big time Bruin supporter. Barrett at 85%. I don't know if I believe that. Kavanaugh at 70%. Roberts at 60%, which I doubt that on there. Kagan at 15%, and Sotomayor, Jackson both at 10%, which I think it's less likely that Kagan, Sotomayor, and Jackson are going to vote anything near pro Second Amendment. Roberts, I think, is going to be a tough one to sway. So, what is that? That's 1, 2, 3, 4. 1, 2, 3, 4, 5. It's going to be pretty close according to Grok on this one. It'll probably end up being 5-4, but I don't know. It's going to be pretty close. Roberts is the wild card on that Hawaii case. On the Hamani case, Hamani, I gotta make sure. Hamani, I think is how you pronounce that. Hamani v. U.S. Odds of these individuals voting pro 2A: Thomas is 100%, Alito 90%, Gorsuch 85%, Barrett at 80%, Kavanaugh 60%. We'll see. Roberts at 50%, Kagan 20%, Sotomayor and Jackson at 10%. So Grok is thinking this is going to be a 6-3 decision that's going to end up pro 2A. So if Grok is right, that's the first two real Second Amendment cases to be heard in decades are going to both fall pro 2A. So I'm curious to see how close that really is. Again, Roberts, it's hard to say. I think Grok's pretty favorable on these percentages that he gives on those two cases. It's going to be tough. On the 18 to 20-year-old bans, again, these are the odds percentage of these justices voting pro 2A. Thomas, 100%, which he's stalwart. Alito at 95, Gorsuch 90, Barrett at 85, Kavanaugh at 75, Roberts at 65, and again, the Kagan, Sotomayor, and Jackson, the exact same 15, 10, and 10 respectively, which is, in my book, is going to be a 0%. They're going to vote for 18 to 20-year-olds to allow to keep their firearms. The magazine ban cases, almost, actually a little bit higher. Thomas is still at 100, Alito at 95, Gorsuch at 90, Barrett at 80, Kavanaugh at 70%, which is interesting that he threw that in there. Roberts at 55, which is still probably too high. Kagan, Sotomayor, and Jackson are still, he has them. Grok has them at 15, 10, and 10, again, respectively. On the felon stuff, the nonviolent felons, which could be interesting, and this includes the illegal immigrant use for 2A. Thomas at 100, Alito at 90, 85 Gorsuch, Barrett at 75, Kavanaugh at 60, Roberts at 50. Again, probably not with Roberts. 20, 10, and 10, which is actually, he has Kagan higher on this one, which is interesting on those three cases. Which still means pro 2A on these ones, which is interesting. We'll see. I thought that was kind of fun just to look at those odds, or at least the percentage possibilities, to see what Grok thinks these individuals are going to lean to. Nonetheless, what is happening in the Supreme Court is a big deal. Obviously, how they decide has lasting impacts on how our 2A rights are going to be sustained long term, and how anti-2A, how they develop the next attack on our rights. So it's important for us to really pay attention to these. I'm going to do my best to keep the information coming to you when these cases hit the Supreme Court, because I want you guys to stay informed. I think it's important for us to know what's going on. I know a lot of time that stuff is super boring. People don't want to hear it. They want to hear about the cool new guns coming out, or what's going on at SHOT Show or whatever. I get that. But it's important for us to know what's going on the retention of our rights. Obviously, that's far more important than anything else that we're doing or paying attention to. Thank you so much for hanging out. I do appreciate your time. Don't forget to vote for Range Minded Podcast for Podcast of the Year. That would be amazing. There's a lot of really, really big podcasts on there. Honestly, to be mentioned, I think, is cool enough. To be nominated is amazing. But the competition, there's some big boys in there that I'm up against. So if you feel so inclined, please vote for the podcast. I'm begging for your votes, I guess. The nice thing is you can vote like a dead Democrat and vote multiple times in a day. You can vote daily at the very minimum, but if you vote for every category, it gives you an opportunity to share to Facebook and X, and then get a bunch of votes back and vote again. And then if you watch a video, then you get more votes again. So technically you could vote 3 times a day if you wanted to for the podcast, which would be rad. And it's all based on a particular email address. So take that for what you might want to as well. It's pretty cool. And it'd be rad if you voted for the show. That's it. That's all I wanted to talk to you about today. Should be good. I was going to talk about how I completely bombed at my first Winter League pistol match, but we'll save that for another show. You can make fun of me about that later. But don't forget, you can find me on Twitter, which I spend way too much time on Twitter than any other of the socials, at Range Minded. You can also find me on Instagram, Range Minded Podcast. TikTok, I don't really spend a whole lot of time there. I'll post memes and stuff every once in a while. That's also at Range Minded Podcast, as well as Facebook at Range Minded Podcast. Feel free to chat. Hit me up in the chats, or whatever the kids say nowadays. You know how it goes. You guys are awesome. Remember, you got to stay safe, stay armed, and stay range minded. See you guys. Love ya. Bye.